These are part-heard appeals in the matter of CJ, DJ and Yankee cases and Wiltshire police and others.
Good morning, my lords. May it please you, may I apologise first for the delay caused by an attempt to make the kit work.
Yes.
Right.
Well, Mr. Bowen, I, of all people, am hardly in a position to criticise anyone for having problems. The only point, really, is it might be helpful to identify the problems a little earlier.
Well, we did.
Right.
We did. It's a perennial problem, I'm afraid.
You lacked the necessary spanner and screwdriver.
When we argued Tyndall, I went there 10 days before, and when I got there on day one, the hearing loop wasn't working.
Right.
On this occasion, we had a conversation a week ago, but forgive me.
Right. No, well, thank you.
I will attempt to accelerate through to save the 8 minutes.
No, don't worry. And just delaying your acceleration for a moment, are we correct in assuming that it's Miss Woodcock who's sitting at the back of court and was present yesterday as well?
Yes.
Yes, it is.
Put your hand up.
Yes.
The lady in blue. Yeah.
Yes, well, we sort of guessed that. Miss Woodcock, I'm sorry we hadn't, as it were, formally appreciated that you were here. Can I just say this? There must have been times yesterday when you wondered what was going on, with the lawyers talking on and on. Can I just assure you, we all understand that you were the victim of a terrible crime. And everyone sympathises on a personal level. And we understand the human realities of the case. But you will understand, I'm sure, that we have to do things in accordance with the law. So what we're all engaged in is trying to be absolutely clear as to what the law does and doesn't say should be the outcome here. So that's, I'm afraid, distinct from the personal sympathy which everyone feels for you. And similarly, I don't know if any of the other claimants are going to be present at any stage, but I hope they too can be reassured that we all understand the human realities of the case.
No,
Yes.
I'm very grateful for that, my lords. Right, so we know 9 years on since the seminal judgment in Michael, 6 years on from Robinson, and the completion, well, maybe not the completion, the reorientation begins, the shift of public policy, or the shift from public policy, subject to, of course, the gap that remains as a result of Lord Mance and Lord Hughes, and exactly where we stand in terms of where policy still fits in, and I'll be coming sort of back to that as I proceed. That shift, of course, in favour of the omissions principle, as you've heard at some length, going very helpfully through all of the main cases. So we say broadly, and a signal from Tyndall, really, is that the law is slightly on the move here, and there is a relaxation that is going on and is entirely legitimate. We don't have a state of status, the law doesn't ossify. So we say broadly, and I appreciate entirely you're not a jury, and I'm not treating you as a jury, but I just want to sort of just put this idea in your heads that some form of I've used the phrase reorientation, some change is certainly overdue. And you might indicate that from the fact that these cases just a bit like the bad fairy at the christening, they just keep coming back, despite the fact that the law, your lordship said the law is not in a state of flux. Plainly, you were right for the wrong reasons. The Supreme Court have looked at it again. They've again said the law is not in a state of flux. But there are elements of it which absolutely have not been dealt with. And that's what we will be struggling with, I say, in these two cases. The balance between claimant and defendant, the state and the individual, we say broadly, had swung simply too far in favour of the state. And that will have particular resonance when we start to look at, and you go away and you think about this, and you think about Brooks and the exceptionality gap, and whether or not that still exists. So we've seen that change with Tyndall and the acceptance of the interference principle, talked about for a long time by the academics and now embraced by the apex court. That process in relation to control, it isn't there in terms of filling the empty category, because we know from Lord Toulson that it exists, the conversation about couch, which we'll look at. So that flexibility is required, whether you find the flexibility within the Tafaris exceptions or there is some legitimacy in the approach of Mr. Justice Ritchie is, of course, one of the main issues. And that can be done without removing the undoubted protection that the police and the state require to fulfil their proper statutory role. And it's primarily done through the exceptions. Of course, I accept that. It's done through assumption. It's done through control and interference. And it's given that little push. This is the end of Tyndall, I think, 86 and 87. Status is not dead. I mean, despite that interesting argument at the end about what we were saying in Tyndall, we were entirely accepting that the status is not in itself enough, because that's what requires a reversal of the fundamental principle in Michael, which we are not seeking. We're just seeking to work at the moment around the edges. And I say that Mr. Justice Ritchie, in broad terms, was faithful to that general position. But what he has done is he has reminded us of something which was was largely forgotten in many respects, is I will say, if not formally binding, the very strong obiter, I suspect that's what my learned friend might say, about Brooks and Smith, that you read about in Mr. Justice Ritchie's decision. All the references are there, and I'll give them to you again. That category is still part of the law, but it wasn't referred to in Robinson, but it was certainly not excluded from the Robinson aspect. The reason that it's there is because without it, in terms of the former policy underpinnings of the Hill immunity, as was, rechristened the core rule at paragraph 34, I think, of Brooks, the reason it was there was to avoid the Osman problem and to avoid the criticism that without flexibility, you then have a Euro-busting core immunity and Article 6 problems. So if we just start quickly, if you turn up the core authorities page and just have a very quick look. Can
I just throw you away, Mr. Van? I can see where you're going.
Yeah. I wouldn't be so sure about that.
But it's impossible.
Yeah.
What you're trying to do is impossible, isn't it, without subverting the core principle that a public authority, be it police or whoever, their actions are governed by the same principles of the law of tort as if they were a private individual.
Correct.
And that is embedded right back. If that's right, you have to persuade us, don't you, that there's wriggle room,
Well,
or would be wriggle room in the case of a private individual.
the problem, which I have discovered for decades doing this job, is if I start a case with a broad proposition, I provoke an answer.
You just have.
No. I provoke an answer. I don't get on to actually the legal material, which would establish where I'm going. But I will face that on.
It's a very elegant way of telling me to shut up.
No, not at all. No. I'm being accused of many things, but elegance isn't normally one of them. The one thing that I was quite surprised about in Malone & Friends opening, and maybe that's because he's keeping it as a sort of real sort of kick in the backside response in reply, is in terms of the warning, if I'm right about the warning being a legal obligation on the police officer or the police service, I can't be right unless I can say that we could have sued the neighbour for not passing law. I mean, is that broadly your lordship's point? I mean, I was going to deal with that
not exactly, but it's close to that point.
Yeah, okay. I will not avoid it. I have some submissions perfected in the 1.5 hour journey in the taxi coming to court, just exactly on that point. And just if I could give you just on it now, just one. In fact, let me turn to it. It's good to work out exactly where we are straight away. I mean, I won't develop this fully now, my lords, but what I broadly say on this is that the equality principle does not require you to ask in each case factually on the factual circumstances of the comparison between the private individual and the state, whether or not in those precise factual circumstances it would be there would be a duty owed by the private individual as well as the officer. Because, of course, there is no, as the academics and McBride particularly talk about, there is no, the underpinning is that you don't have compulsory altruism. You don't, we all have, the rule that underpins the emissions principle is that we are able to live our lives as we please, that we have the autonomy to be able to decide when to do good things and when to do bad things. But the position is different for the state. So when you look at these problems, what you have to do is to apply the general principle. And the best example maybe is if I know my neighbour is beating his child, or beating his dog, or beating his wife, I don't have any obligation to do anything. Lord Gough said years back in Smith and Littleworth, you know, there may come a time where that principle is simply repugnant to modern thinking. And many, many people think it is. That there has to be some form of legal compulsion in that particular circumstance. But I can hear the child screaming, and I don't have to do anything, even if I know them quite well. I mean, it's different to the child drowning in the pond or the you example of the man about to walk off the edge of the cliff with his head in the air, because they're strangers. But the state, for the state, there is a compulsion there on the state, Barrett. There is no private equivalent for that. I mean, there are examples. I mean, there are many, many hypotheticals that one can put up in the air here. But it is simply not as simple as simply saying, insofar as that we establish the assumption of responsibility, the special relationship with everything that is in play as a result of the material that you see in Lord Justice, I mustn't promote him, Mr. Justice Ritchie, that there has to be, you have to be able, within the equality principle, which is, if you look through exactly what Lord Reed says in Robinson about it, there are words throughout. If you do a word search to generally and normally, that it is not a universal principle. And it's also a principle which was based upon Dicey's work in the 19th century, which is all about what's the phrase? No matter how high ye be, the law is always above you. So the fact that you are a public official, the Prime Minister, whoever, the ordinary law applies to you. You cannot use your position as a public official to gain some form of immunity or differential to the ordinary individual if he did the same thing, would be liable in private law. That's what it was all about. But it's been, and I know this is fundamental, I'm not trying to change this, and I can't change this here. But it's been switched as a result of the equiparation between the private individual and the state to a position where the state has this sort of overwhelming advantage. And it has the overwhelming advantage because it's now said that, well, it's only if Joe Bloggs was liable that a professionally trained, properly resourced state organisation who exists for the very purpose of welfare generally, protecting life specifically. And that many academics, judges, individuals, the common man in the street would understand that. Now, this is the problem with the environment I've now created by making the points that I have. But I mean, that's the broad, I mean, there's more probably to say, and I'll go back to it. But I would submit as strongly as I possibly can, beseech you, that before, if otherwise you see a route through in this case, to knock it on the head as a result of a simple application of the equality principle is something that has really not been thought through. It has not been looked at properly in the authorities. When we argued Michael, when we argued Robinson, there were not full submissions on that. That's something that has come down from on high. And the way that it's been expressed by the Supreme Court, by reference mainly, I think, to cases which are really old, sort of early 20th century cases. That is something that needs to be explored. And this is your opportunity to explore it.
Whether it's an opportunity for us, you must have raised these arguments in Tyndall in the Supreme Court.
Well,
because otherwise you couldn't win.
It wasn't developed in. I mean, I have the I have the written case in Tyndall, and I'm very happy to make this available to you and make Mr. Warnock's version available as well. There was. I mean, there's nothing I think that one sees in the actual judgment about on this particular issue. And in fact, if we just take up Tyndall, it's in the core bundle, just towards the end of page 522 paper, 524 electronic. So 85 through to 87. There you have that. So the last head of liability suggested by Tavares and Steele is A's status creates an obligation to protect B from danger. In their article, Tavares and Steele developed an argument that the police have a special status derived from the fact that they are the primary body legally entitled to intervene and use force to protect citizens from criminal activity. They argue that this status and the corresponding dependence of members of the public on the police for their safety are enhanced by the fact that a victim cannot generally protect or reasonably be expected to protect herself against the threat of violence. They propose that the police should be held to owe a duty of care to a person who, as the police know or ought to know, so the crucial foreseeability issue, is at special risk of harm, negligence, than the Cambridge article that you have in the bundle. Whatever the merit this argument might otherwise have had, it's irreconcilable with the decision of this court in Michael. Tavares and Steele acknowledged this in their article and expressed the view that Michael should be overturned. We have not been invited on this appeal to consider departing from Michael. Perhaps we should have done, but we didn't. And given the weight of that authority and the further body of authority since founded on it, this would not have been a realistic argument to advance. In their written case, counsel for the claimant made a submission that given the position of the police as professional emergency responders, the status exception, though not an operative exception capable of supporting the existence of a duty of care on its own, works in tandem with the other exceptions, which are individually capable of supporting a duty of care. This submission was not developed either in writing or orally, and we can't make coherent sense of it. It appears, however, to recognise correctly that if, as we have concluded, no other principle supports the existence of a duty of care, in this case, the status of the police cannot do so. So they seem to be leaving there open I mean, we didn't develop it because we thought we didn't have to. But there, they are certainly not ruling it out. And status, and you will see, I mean, I think I'm going to try not to get too bogged down in either authority or references to the skeleton, but I know you'll read everything incredibly thoroughly when you depart. But there are numerous references. A.J. Allen is one, the case that we debated in the Court of Appeal in Tyndall, and Selwood, very interesting and important judgment by Dame Janet Smith, Lady Justice Smith, which is, again, pre-Robinson, but important case, a very important hypothetical in there as well. And they talk about how there is interchangeability between the exceptions, how they merge. AOR merges with control. So you can have cases which can be explained by way of making matters worse, which could also be assumption of responsibility. So
you don't need assumption of responsibility if you make it as well.
Right. But the law of tort is all about, look at what they said in Caparo. It's all about labels. There are all of these principles or all of these judicial techniques.
Surely one of the major points is that Tavares exception 2 is simply restating general principles, first principles, in a different way. They've listed 4 circumstances in which they say a duty may come to be owed. But so far as Tavares 2 is concerned, the Supreme Court say that is, and speaking entirely for myself, I would agree, even if it wasn't binding on me, that it's a classic example. You do something which gives rise to a risk of personal injury, you owe a duty.
By stopping somebody else coming to the rescue. Yeah. But it can also work, as they say, and I think they say specifically, at either 45, is it? Or I think 45, you view defendant's activity as a whole, and that goes some way to explain the difference between acts and omissions. And then 49, I think, is maybe the crucial paragraph, which I say really eviscerates Mitchell as any kind of a bar in our case, because there was the creation of a danger, making matters worse, supplying the East Suffolk principle to the meeting. That if they hadn't had the meeting, you don't look for what you were saying you didn't have to do in OLL, and then for understandable reasons in Tyndall decided that you had to argue against yourself and look for the positive act that causes damage. You don't need that. You just need to look broadly at in terms of, as long as you got negligence at a later date, you don't, i.e. you slice the salami. You have a position where generally you've made matters worse, and you've done that by creating the danger. So we see no substantive difference between these contentions. The exception relied on, that A has done something which prevents another from protecting B from a source of danger, is on analysis an instance of the general rule, a particular way of making matters worse by creating an additional danger. Now, I may well get to it in due course, but also it works as an exception, and I think it's the end. This is not to deny that this particular form of making B worse off merits particular attention when one is considering liability for omissions because of its close factual connection to protecting a person from harm. So if you create a danger, or rather you create a danger in the sense of making matters worse. So you make matters worse, my neighbour example.
Provided it's foreseeable, which is the gloss that...
Yeah, that's where it all fell apart for us in the Supreme Court. Then you then ask yourself, have they omitted to mitigate the problem? So there is then a duty to do something to make things better, having made things worse. And you ask yourself, well, did they do that? And here they didn't, because they didn't give the warning. But I'm keen to get into the detail of it. But I say there's nothing binding on you here to stop the court really finding a way through if that's the ultimate outcome. Because it may be said that Mr. Justice Ritchie was obviously very well versed in these things. It can't possibly be said he hadn't read Robertson and Michael. He quoted most of it. But he could see a potential problem. With the alleged rigour of the assumption test. 115 of Michael, 135 and 138. Now, I've got ways around that. I say we can satisfy it even if you impose on Mrs. Woodcock the rigour of an economic loss Headley-Burn model, which many of the academics, all of the stuff from Clark and Linsell is in there. We've got the articles. I don't possibly have time to take you through it. But there is real concern that the legal structure that some people say is inevitable because of Michael just does not work for this type of case. And that's what I'm going to come to now, which is why if you look at what they say now at apex level about assumption of responsibility, and Lord Burrows has done it both in HXA and in Tyndall, that there is elasticity in this, that assumption of responsibility changes and has different requirements in different contexts. So there are many ways, and even if I'm wrong on that, there are many ways that Michael can be distinguished. It can simply be distinguished factually. But
what is this type of case?
It would be a mistake to say this type of case is any form of case where there is some suggestion that there was a failure to protect.
No, I'm just asking what you meant by that phrase.
Well,
because speaking for myself, I'd quite like to get to this type of case.
I'm sorry?
I'd quite like to get to this type of case, whatever it is.
Yeah.
Focus on the cases before the court.
Well, could I now just start to work through my pre-planned route?
Of course, but would you be kind enough, first of all, to answer my question and simply help me with what you meant when you said there is a problem applying the Michael principle in this type of case? Well, I just want to know what this type of case is.
In a case where there is an assumption of responsibility because of the specific and close nexus and course of dealing that we have, i.e., because you cannot answer or satisfy the test that is said to exist in Michael as a result of complete certainty. The police will arrive in exactly 5 minutes. And I'm going to go through all of that.
All right.
So if I now go back to my broad submissions, and it may well be I've covered a lot of this now. So I say, so this section I've called just got broad submissions, my lord. So for the purpose of the AOR finding, at I do not want a file failure. Forgive me for a minute. There's something wrong with the references here, my lord. So Robinson and Michael were quoted in detail. I've made that point. The judge analysed the trial judge's treatment of the same. He did that at, you don't need to turn these up, you've seen it, paragraph 22 to 32 of the judgment. That's call 58 to 64 of the Woodcock, of the Woodcock judgment. We say he did treat it as an omissions case, and he acknowledged the general rule, and then he mapped out his 5 criteria as his toolkit to decide when a duty to protect, here, but the scope of which was merely a warning, would exist, but always as an exception to the general rule. So there we're clearly in omissions territory. And the satisfaction of those criteria are then capable of amounting either to an assumption on what I will be submitting to you is that elastic test. And if it's necessary, and he was plainly riding 2 horses, it bites and can fit into the exceptional or special circumstances category. That approach is consistent with Lord Reed's approach in Robinson, where you will see a careful reading through is a repetition of language that we see prior to that in Brooks and Smith, which is in the absence of special circumstances such as an assumption of responsibility. So an assumption of responsibility isn't the only route through. Now, Lord Reed, we say, on a proper analysis of this, has provided some leeway, and that leeway may well be to accommodate the views of Lord Mance and Lord Hughes, which has, we say, left room to preserve that exceptional category. And what Mr. Justice Ritchie has done, and nobody's done it before, is to provide content. And its content, and in doing that, he's charted the way to decide whether an assumption of responsibility is to be imposed on a defendant. And again, the simple scope of the duty being simply to convey the information. And that is very, very different to a broad duty to protect. Now, I accept that that was being argued by Mr. Davey, very fully pleaded out, saying that the duty went back several days. There's failure to arrest, failure to do this, failure to do that. That is a much, much broader spectrum than a simple duty to convey information, which we see, and we see that particularly in Rush, and we see it also in other cases.
So to be clear, you're not contending for the broader duty.
I'm only contending for the duty that the judge found. I'm not going any further.
Contending for the broader duty that was pleaded out.
No, because that was rejected. That was rejected. I mean, it would be legally possible if the test was satisfied in relation to assurances given at an earlier stage. We almost get there sometimes. I mean, I was planning to do this. I don't know whether I'll have time, but you need to read through track 2 to track 13 really, really carefully. And I've done that, and I've got it on paper, and I was planning to take you through it, but I think simply I'm probably not going to have time to do it. But that will show that if you then compare that to to paragraph 138 of Michael, where Lord Toulson simply says, well, there was they didn't give an assurance as to exactly when the police would arrive. She wasn't told to lock her doors and windows. This case, factually, is a country mile away from that. So I say there's nothing revolutionary at all about what he's done. If you look at his emboldened use of type throughout his judgment, this is the appeal judge, Mr. Justice Ritchie, where he goes through those sections of the judgment. He is pulling out the fact that special circumstances such as one example, page 60 or page 59, you see it at paragraph 24, paragraph 25, foot of 68, foot of paragraph 68 at 61 of the call, and so on. And I mean that's important. Now, we say, therefore, on our analysis, these facts can meet the conventional requirements of an assumption, which are not blocked by Lord Toulson's judgment in Michael. So, broadly, we say that I accept that if I am wrong, and you say that Michael is a complete red flag, and it's impossible to have an assumption of responsibility in any more nuanced or flexible way to reflect a different set of facts, then there's plainly a big problem with assumption of responsibility. And then you have to move on to something else, and that's either interference, making matters worse, control, or exceptionality. And if that's the case, either can't happen here, Michael has to be reversed, something that Lord Burrows plainly and Lord Leggett are not attracted to. Nobody's attracted to that. The answer must be to find some acceptable jurisprudential route to allow for what all of an extremely strong generation of judges were saying. Lord Bingham, Lord Stane, Lord Hope, etc., Lord Carswell, all of those celebrated judicial minds were saying that there's got to be something at the margin. If there's not something at the margin, then we're back up to the ECHR and saying that what the law has now created through a tight and insulated box by the omissions principle is an immunity. And that cannot be what the law is. So I say we don't need to do that. All those routes are available. There is nothing here in precedent terms that stops that approach. Brooks and Smith, it cannot be said either that Brooks and Smith have been, and I don't think the learned friend, to be fair to him, submits this, are somehow implicitly repealed. I mean, there is, I don't have it with you, but there was a discussion when I was arguing Henderson, the case about the mental health case about the woman who murdered her mother. I mean, and Patel, and how the effect of Patel in illegality cases, how that, whether or not there had been an implicit overruling of Gray and earlier cases, and there's a whole lot of jurisprudence about exactly what the courts should do under those circumstances. We haven't actually put any of that learning before you, but on the paragraphs of Robinson that Mr. Warnock took you through, there is nothing to touch Brooks and Smith, as long as Brooks and Smith can be explained by reference to an omissions analysis, which there's controversy about that, about whether they can or not, but Lord Reed says they can, and that's fine. But what he doesn't say is that his approach, which is criticised very strongly by the not quite formally dissenting judges, I can't remember the Latin name for agreeing with it's at the beginning of the judgment.
Dubitante.
Thank you. Yeah, the dubitante, yeah. So in a dubitante sense, they are saying, and supported by the editors of Clark and Linsell, I have the reference for you when I get to it, is that there are huge problems in trying to say that the omissions principle can answer everything. And one of the problems may be that we discover in this case via Mr. Justice Ritchie's approach is, well, what about the exceptional category? And just for your note, we're going to get to DSD. And DSD, even though it was a human rights case, is extremely significant because there, the government, the police service, and with the government intervening, we're saying that the full weight of the immunity and all of the common law principles needed to be reflected in human rights law. And that means that there's no Article 3 investigation of the type that the judges found. Now, in doing that, they go through Brooks and Smith, and both sides of the argument in that case were saying that Brooks and Smith were good law. There is nothing that says that that category no longer exists, either expressly or implicitly. And if I'm right on that, or rather, forgive me, if Mr. Justice Ritchie is right on that, then I say, irrespective of anything else, Mr. Warnock's case collapses. Because then you've got an appeal judge. This is the third appeal. This is a second appeal. So he's looked at it and he's looked at all the facts. And obviously you can look at the same material, and I suppose, and of course you can take a different view. But he has populated that exception by reference to solid criteria. And that solid criteria is not a green flag for any case to be just put in a case on the margins. It's got to be a truly exceptional case. And we say this is one. Now, so if I could now go through my section on the factual reasons to distinguish Michael. The chronology of the facts in the skeleton begins at, the chronology of the facts in the judgment begins at paragraph 61. That's supplementary bundle for your note, 61 to 76. And unlike Michael, there's a long history of domestic violence going all the way back to 2013. The couple separated on the 4th of February 2015. That's paragraph 61 of the judgment. I don't want to read any of this, they're just referring to it. But if you take then from 77 to 89 of the bundle, you get the following. Multiple breaches of bail, multiple death threats, really the most conceivably serious sexual abuse and assault of both the children and Mrs. Woodcock that you can imagine. Criminal damage, pleadings for the officers to attend urgently on the 17th and the 18th, the day before the assault, the climbing over the fence, trying to break through the window and the door, the fact that he was happy to breach bail, incorrect risk assessments, medium should have been accepted as high, a careful reading through the tracks from paragraph of judgment 80, or paragraph 80 of the judgment onwards, that's what I think a lot of this is based on, sets out the safety plan. Unlike Michael, told in an emergency to lock all the windows and doors, have friends and family over, get into a locked room. You see that in, let's take out a couple of examples, supplementary bundle page 80. So if you just have a quick look at that.
80.
Page 80 of the supplementary bundle, yeah, which is track. Track 8.
Is this page which has 542 at top right?
Yes. Yeah. Keep reviewing that. Keep an eye on that. Keep all your doors and everything locked. Don't answer the door to anybody, etc. Advice given. Obviously, if he does turn up again, there's any banging, call 999. The police knew her phone number. They called her. There are text messages on numerous occasions. Examples, for instance, of James Thomas's welfare call, SB 68. So I'll just flick through some of these. Track 7. So that call was made at 16:41 on the 18th of March, 2015. SB 68.
Sorry, when was it made?
18th of March at 4:41 in the afternoon. Now he is the call handler that took the neighbour's call the next day. Supplementary bundle 68. He knew all. This is really important. He knew all about the threats to kill. He knew all about the background from his previous involvement. You might not know it from his witness statement, which for your note, don't turn it up, SB 121. Now, I would ask you to read all the recorded telephone calls and radio tracks from SB 49 to 98, but can I just give you some highlights? So she's encouraged not to drop the charges. She'd been offered an arrangement by RG, drop them and I'll leave you alone. Go to 57:58. And that's from the foot of 57. He said basically, if I don't drop the charges till the 26th, because he's on bail until the 26th, the police or the court will decide what's going to happen to him. He said if I don't drop my charge, till then he's going to kill everybody in my house, and especially me. He said, you can record this and show it to the police, which I have done. I'm really scared. Basically, he says, that means I'll leave Rushton, where they live. Sorry, he'll go to London and leave Rushton if I drop my charge, and he'll never do nothing to me again. Okay, says the operator. So he basically wants a kind of arrangement with me. Yeah, operator, and this really crosses the line. Well, that's not going to happen, is it? Mrs. Woodcock, I don't know. No, Mrs. Woodcock, who's obviously in a real state. But I'm in two minds. Operator, yeah. No, don't be, darling. Operator, Esna, don't be. We'll sort him out. Don't drop the charges. I'm gonna. Esna, yeah, but what happens if? Okay. Operator, okay. What's happened? Okay. What's going to happen? I've raised another incident. Are you at home? And there's a discussion about when the officers are going to get there. So we see there Influence on her being exercised by the call handler. We'll sort him out. Don't drop the charges. Nothing like that in Michael. Michael was just, I mean, Joanna Michael was appallingly tragic case, but she was really no different to many members of the public. Yes, there had been some tit-for-tat stuff a couple of years earlier, and one slightly more recent event, but nothing on the scale of this. So we'll get officers straight out to you, SB 59. Yeah, that's first line of the last penultimate box. I'll send you a text so you can see there. That makes good my point about how they used SMSs. Page 59, supplementary bundle. I'll send you a text and I'll get some officers straight to you. Now, they might have reneged on it, but she was depending there on an immediate attendance. We didn't have that in Michael. That was one of the reasons that the 115 test could not be satisfied. So the call handler, Thomas, who takes the neighbour's call, is involved in internal discussions about the case then between supplementary bundles 64 and 68. So if you look at track 3, that's an internal discussion there between, now Gaz is the chap who's called Marriott. I'm not quite sure who Dave is. Dave, I think, is another officer. But if you pick it up at 64, track 5, this is a conversation between Marriott, who's another call handler stroke dispatcher, and the call handler, Thomas, who took the neighbour's call. They're talking there about the urgency. And then track 6.
Can you just tell us what time track 5 is?
Sorry, forgive me?
What time is track 5?
What time? I can't answer that immediately, but what Mr. Davey has been trying to do, and I'm not trying to be controversial here in any way, but there is a long, neither of us really want to burden you with the discussion that's been going on between our respective juniors about the chronologies and attempting to agree exactly the facts, the timings of the call, all that kind of stuff. We have done that. We've done it again overnight. I have a grid which is thoroughly referenced. Copies I can hand up to you, but I'm not going to now. I think the other side have them, but they've not had them for very long. And I discussed this with my opponent, Mr. Warnock, before the case, and that we think, subject to him saying otherwise, that we think it's sensible to agree a document that we present to you after the hearing, which is then agreed.
Is this going to be like the chronology that we've got with additional detail?
Yes, there are two, at the moment there are two competing chronologies. There's a chronology that was put into the bundle by the other side, I think as far as I'm aware, without us agreeing it. There's a background to that I won't go into. There were then more attempts to see whether or not we could agree another chronology. That didn't happen, so last Monday we sort of gave up and just lodged one, for which we formally need permission. But we didn't want to talk about this at the beginning of the case. So I think, respectfully, I suggest the best result.
If it helps, I can short-circuit this, because I'm happy to proceed on the basis of the chronology which my learned friend filed.
Yeah, okay.
Thank you.
But I'm happy at the moment just to go through, just to finish this section in relation the way I've done it, and then I will make that other document available to you. I'm grateful, Mr. Warnock, thank you. So he makes the welfare call at 1641, supplemental bundle 67. Prior to that, we see, if you look at 66, you see discussions between Mr. Thomas and one of the other officers. So there's a terrible... Is it only me that can hear dreadful feedback?
There's a lorry reversing outside.
Everything is... Oh, okay. Right, thank you. So, the point that I'm driving home here in terms of reasonable foreseeability when we're looking at the making matters worse question and applying Tyndall is that when he gets the neighbour's information, it's not like there's a blank sheet. So all of the points that I say absolutely hopelessly bad on foreseeability and that with respect Mr. Holcroft was making about the need for training, it's not the job of call handlers to think about making calls. It is absolutely as plain on the nose as the nose on one's face that given everything, that information and knowledge about the immediacy of the threat, the seriousness of the case that he gets before, that you see very thoroughly evidenced in all of these documents. And he then gets the call and he doesn't pass on, the guy is outside her door. He knows that there will be 10 minutes or so at least for the officers to arrive. And he doesn't phone to say, for God's sake, stay in your house. I mean, and that's the foreseeability bit. So he has all of this knowledge invested. I mean, that is the point. So we then see, so I was on 67. So Mrs. Woodcock tells him all he needs to know about the immediacy of the threat. 72 of the bundle. It's a long call. They talk again about dropping the charges. So foot of 71. He's just going home. He's making out. He's sniffing around me because he just wants me to drop the charges. That's what this is all about. James, that's what he wants. Right, okay. That's what he wants. He said to me, if I drop my charges, that's what he wants. He's going to disappear and go to London. He's trying to make an arrangement with me. I said, no, I've done that before, but you never disappeared. And this time I'm going to stick with it. I'm not going to drop the charges. Woodcock. He said, I promise that I will go, and I don't want to go to prison. I don't want to go in prison. If I do go to prison, I promise on my life I'll kill you. That's what he keeps saying to me. And then the next box, James, so I don't think we're going to get to you while you're still at work, so it's likely to be at home. So the timeline, having been told that they were going to get straight there, extends throughout the evening until the eventual attendance of the police, I think from memory, at 10:25. So there's discussion about whether when she'll be at home, and then he talks then about he shouldn't be trying to, this is foot of the page, he shouldn't be trying to force you to withdraw a statement. So if he's done it before, I can't see the officers wouldn't want to arrest him. But they're more qualified than I am. And then at 73, it's specifically, I can deal with the incident. And you see that she says she's worried about her kids in the middle of the page. Asks him again. She's all over the place. Shall I drop the charge? Because at the end of the day, it's my kids. And another way, another way, no one does. And anyway, nobody does anything. So what she's basically saying is, I can't rely on you because you keep saying you're going to turn up. And where are you? The officers aren't here. That two police officers yesterday, they told me they were going to speak to him. No one did speak to him. And then he says, So that means he doesn't know anything about it. Of course he will come and chase me. Of course he will ask me to drop the charges because nobody is warning him. So what if I will find out their name? So what? I will find out their names when I get home. That's a discussion about who the police, there's some confusion about who the officer in charge was and who had attended. James, okay, I understand why you'd want to do that. I don't know what happened with yesterday's incident. I wasn't here to know that's so all. All I can deal with is the incident that you reported yesterday, which is why I'm calling you back.
Reported today.
Which is why I'm calling you back now to try and sort out. I can look up yesterday's incident, etc. And then SB 74, just about an inch or so up from the top. James, okay, I'll have a look at that as well. I'll log that as discussed, and as I say, we'll literally get somebody to you after 8:30 when you got your kids, when you got the children. So again, that is the sort of certainty that seemingly was lacking in Michael that we've got here. Precise timing required by Lord Toulson at I think paragraph 138, that's for your reference, 152 of the core authorities. Then track 7 ends at SB 74. Track 8 is another 999 or 101 call. She's really scared, so 75. Hi, it's really important. I keep calling the police 101, but it seems like no one's happening. Someone said they're coming to see me at 8:30 tonight. I've got an incident number. And then you can see, told at the foot of the page, let's have a look for you, lovely, right, take deep breaths. Foot of the next page, I mean, you are very frightened, aren't you? Yes, I am. Seeing my window like this and seeing him on the CCTV at 3:30 while I was at work. That's when he climbed over the fence. And then that discussion about the fence goes on between 76 and 77. And then middle of 77, operator, it's okay, love, don't worry. I'm going to see what I can do for you. All right, just take a nice deep breath for me. You're doing really, really well. You've got this far, haven't you? And then page 81, more discussions about the fence on the next 2 pages. And then at 8, you pick it up at 80. Operator, this is 1, 2, 3, 4th from the bottom. Keep reviewing and keep an eye on, I've already shown you this, keep all your doors and everything locked. Don't answer the door to anyone that you don't or can't identify first. Obviously, if he does turn up again and there's any banging, I'm trying to get to the door, dial 999 and we'll come out to you straight away as an emergency. So that's another clear reference to timing. Are you all right? Not really. And then Woodcock at the top. I've called you. They say it's an emergency, but nobody gets here. And then the next line. We're going to get to you. Just try and keep calm. We're going to get to you. We have you. We do have you down, and you are a priority. We will get to you. You just have to sit tight a little bit, just for us, just a little bit longer. And then it'll all be sorted, and it'll all be fine. Just keep your phone close, keep it on charge, make sure there's enough charge on it. And then, page 81 again. All right, then if any bangs, knocks, any shouting through your letterbox, anything like that, call 99 straight away. We'll come out as emergency. Operator, 2 from the bottom. But don't think we're not going to do anything. We are doing something. We will get to you this evening. I mean, I'm labouring the point, but it's so important. Track 9, we've timed at 9:50. That's the next page, 82.
8:50.
Yeah, 10 to 10. Page 82 is track 9. Another call. She's still waiting. I'm still waiting. You see that? 3 boxes up from the bottom. 83, halfway. There's then a discussion about when they should come. I'm at home, I'm still waiting. Operator, what time are you going to be up till? I'm here, I won't go to sleep, but obviously it'll be a help if they come early because somebody's trying to break into my window. It's on CCTV, I am shitting myself.
This is the police calling Miss Woodcock.
No, this is her. This is a 999 call, or 999 or a 101 call.
It's not. It's the first line.
It's the police calling her.
Oh no, hang on, sorry. EW, hello, operator, hi. Oh yeah, sorry, forgive me. Yeah, I didn't spot that.
It's top of page 83, second box. I'm calling you at the moment to apologise we haven't yet attended.
Yeah, sorry, forgive me. Right. I'm grateful. So officers then attend, and we get that, don't turn it up, we get that from paragraph 78 of the judgment. And then track 10, so they then attend. I think they give safety advice, and all the detail is then in the judgment. And then track 10, this is a rather unfortunate call. There's no evidence of this, forgive me. I'm told over this common ground or not, but I'm told the Crown Court judge at the trial was extremely critical of what you read if you read through track 10. It's a panic call. She is hysterical. He is trying to break down her door. And she calls, I won't go through it all, but you can see 85. She's screaming, operator, right, Woodcock, please, screaming, operator, can you please calm down? Then she's inaudible. Listen, I can't help you if you're just screaming down the phone. He said, okay, he said he's going to kill me. You need to move away from the door. I can't, because he's breaking can you? No, come in. No, come in my room. Listen, what's your name? Gives her name. He makes her spell the name, or he or she makes spell the name. We haven't worked out the identity of this operator. I'm in my house with the kids. I haven't got a lock, and he's trying to break down my door. Operator, for the sake of your children, you really need to calm yourself. Okay, thank you, okay. Operator, so the door doesn't have a lock. But he's going to kill me. Okay, he's going to kill me. He said he's going to kill me. Listen, you need to answer my questions and calm down. The sooner you answer my questions and cooperate, the sooner I'll get somebody to you. Hurry, please. Did you say screaming? Essen, please, screaming. Listen, I can't, crying and screaming. I can't help you if I can't understand what you are saying. You need to calm down. Okay. Thank you. Right, what's his name? Reza. How do you spell it? R-I-Z-A. Right, and what's his surname? Please stop screaming. It's not helping the situation. Okay, his name is Guziruliyert, and then spells it out. Thank you. Where are your children? How old are your children? Woodcock. Oh my God. Operator. Right, you need to stay calm for the sake of your children, please. I'm sure they don't want to see. Okay. They don't want to see you in this state. Esner, they're here. Operator, who are here? No, I'm asking my kids because I think both the door and come in. Right, do you have a lock on the door? Yes, I locked the door, but the door's locked. He's still trying to break my door down. He broke the window earlier. Did what earlier? And there's talk about that. And then she goes through, and you'll see this if you compare it to the checklist of questions at SB 26. That's a mechanical list of everything that they're supposed to ask. So the guy's trying to break the door down. Do either of you have a firearm license? What? Do you have a license for guns, firearms, etc.? Oh my God, does he have any weapons? I don't know. Has he got any weapons? I can't see him. All I heard is breaking in. He's trying to break the door in. Oh my God, please stay calm. Is he drunk? Has he taken drugs? I don't know. I haven't seen him. I don't know. What do you want me to do? Sorry? All right, we're on our way. Now, presumably during that time, he or she has pressed the red button and the police are attending. So, with the reference to the schedule that I hope we'll be able to agree, you'll see all the contacts, you'll see all the chronology, and that will give you the full factual picture.
If you go to the top of 89,
yeah.
picking up on what you last said. So he's at the front of the house, he's rushing, because the officers are asking if he's at the front or the back of the house. So do we understand from
Yeah,
that
the officers then attended.
that whatever criticisms may be made of the
Yeah.
operator,
Yeah.
they had done something
The officers at this stage
to
they
get
attended.
to get the police to go?
I think what must have happened is during that rather unfortunate call, seems to be at some stage, the operator must have realised, well, this does sound quite serious, I better get him out. So then they come and they attend.
We don't know when.
Well, we do, in fact, if you read on, they arrive at the end of the call.
Yes, but we don't know when the police were alerted to go.
No.
Yeah. I mean, but all of this material goes to the knowledge of the police, the extreme risk, because the gravity of the risk is one of the issues that I think Mr. Justice Ritchie was looking at in his criteria. So it's really important to focus on the facts and then ask yourself under the common sense. Well, it's always sensible to start with common sense. The common sense question: when that call comes in from the neighbour, given all of this history, all of which is on the log, and of course, the call comes in, it's urgent, the guy is outside, he's going to attack her when she comes in 15 minutes. There's not going to be time, I accept, to read back through a great long log that will be there on the computer system. But Thompson knows, he absolutely knows, even if he doesn't know all of the detail of this call, he knows the general picture. And he doesn't, and he doesn't think of calling her. And you don't need to be a rocket scientist to realise.
We followed this, but what I think is absolutely critical.
Yeah.
If you look at the head note to Michael, which is on page 115 or 117 of the electronic number.
Can you just bear with me a minute? So page...
Say 115.
Which, page 117 of the electronic
117.
bundle, page 115 of the...
Yeah, I've got it. All right, yeah.
Now, obviously, it's a head note, so it's sanitised compared to the raw detail that you've just been reading to us with such potency.
Yeah.
But the police in that case were told unequivocally that the former partner had come to her home, found her with someone else, bitten her ear especially hard, and said he was going to return to kill her.
Well, yeah, not heard because of a problem with the kit.
Okay.
Thought it was hit.
It's hit, but then at a later point in the call, she reported that the former partner had said he was going to return to kill her.
Correct, and then not passed on.
So, in all, what I need
get
to
your
understand,
Yeah.
in all essentials, what you've read with the raw potency of the actual phone calls, is there in Michael? Or if it isn't, what's the distinction?
Well, the
distinction?
The crucial difference is that in Michael, there was effectively a sort of systemic failure in terms of passing on the information internally between the two officers, but there was no control in any way of the risk. There was no control of Cyron Williams, who was out and about. He'd bitten her ear, gone off with the new boyfriend, and driven him home.
So your point of distinction is control.
That's certainly one point of distinction, yes. I mean, I accept that this was obviously a dreadful single event, a call without the kind of course of conduct that we have here, and a real distinction between the police service providing her I use this phrase, protective service, going all the way back to 2013, but we can ignore that. In the run-up, the intense run-up of the few days before with the confrontation in the street, some event that happens at Tesco's, and then everything that I've gone through in relation to what happened on the 18th and then the 19th. You do not have that in Michael. In Michael, I accept, yes, of course, there is a conveying of information that a member of the public is at serious risk. I accept that. Of course, we said there was enough factually in Michael, but, I mean, with enormous due respect, who am I to, I mean, I was addressing a 7-judge court. They weren't that interested in assumption of responsibility. We had a probably far too complicated written case on every aspect of AOR going back to almost the 12th century. I mean, I tried not to take it too personally, but my main point, 1 paragraph. There's about 8 lines on AOR. Lord Toulson...
Let me just interrupt you, Mr. Bowen. I'm not sure this is going to help.
I'm sorry?
I'm not sure it's going to help.
What?
Refighting
No,
battles.
I'm not refighting Michael at all, but the point I think that your lordships should be aware of is that the battle lines in Michael were not the omissions principle. The omissions principle, as I recall, was not addressed by Mr. Panic. It wasn't dealt with us. It came up in about 1 exchange with Lord Mance. It was all about the Hill immunity, policy, and assumption of responsibility.
But
when it went through the ringer, it came out as a seminal readjustment of the law of tort.
to which we have to be loyal.
Of course you do. Of course you do. But what I am saying is assumption of responsibility was not really the focus of the argument, or rather of the judgment.
So are you saying that the points of distinction between this case and Michael are control and assumption of responsibility?
Yes. Yes. Certainly control of risk.
Discrete.
Control of risk. And I'm going to be taking you through the important sections of Couch.
Thank you.
Which again is not disowned by the Supreme Court. Important that on control, I'll just pull it up again.
Well, I'm going to just invite you to do that in 5 minutes' time.
Of course.
We'll just take a short break. 5 minutes.
Court right is able.
Did another spare?
No, but I did tell him to bring one at lunch.
Okay. You conveyed the information. All right. Okay.
I've already got sandwiches. Do you want to do that tomorrow? But I should do that tomorrow. Which hall are you thinking of? Yeah. Is that all right?
Can we get in? Hang on.
Hotel.
Yeah.
All right. So I was offered the.
So
Yeah,
so
see
we
that.
got all the rest.
I was offered the Premier
Document 169. So that's
Supplementary.
So I said,
So three references in the supplement.
I looked around.
So SMS.
There was some Kensington was not cheap, I thought I thought it was 50 quid. That was a bit, the room's a bit sort of dated. Breakfast. Yeah, you think Hilton, but it is, you go,
So,
Where is that grid? Andrew, you've got this, haven't you?
I have,
Yeah. Okay.
I haven't had time really to go through
Yeah.
the next because I only got in just before we come into court. Is it the one you gave me this morning?
Where suddenly Charles did
Which one is it? Is it the one you sent me at the weekend or the one I got this morning? The one I got this morning.
Is that the same thing?
That's the one I want to check. Yeah. So I haven't had a chance to go through it.
I thought, drivers.
So is this, you were saying a bit more detail?
You see, the references are references there to the Murdoch, Ritchie, Scott schedule, which is at the beginning of the supplementary bundle, I think. And then Doc is supplementary bundle.
Where's the reference to
All these references.
Trial judge.
Oh, appeal judge.
Appeal judge.
Yeah, Murdoch, Ritchie, Scott schedule, and then supplementary bundle.
There's a bit more detail in the chronology.
Yeah. I mean, they all need to be sort of strung together.
Can I, if you're handing it
down, they can't hear.
Where are they?
I literally went home yesterday and
Where
I
is
was
it
like,
here?
please can nobody talk. If
Yeah, no, we've got
no one ever does.
I go back.
I live with.
This one here, that's bottom.
So they know more about.
Yeah, I've taken two.
Because that's the kind of thing I see day to day.
This is 21169.
Where on the?
All rise if able.
Yes, Mr. Mac.
Lord, we've put before you the document that Mr. Davey completed overnight that my learned friends have got. And can I just make one reference to it? We'll revisit this with agreement and amendments if necessary. And you'll see, can I just show you how the grid works? This is a summary of events from the 4th of February, taking in the transcripts of the calls to the police by the claimant, from the police to the claimant, and between the officers. And what Mr. Davey has tried to do, and whether it's I don't think it's a completely full analysis yet of all of the evidence before you, but in the grids at the top, if you look at page 1, you see all of those numbers which are then repeated on the following pages. The TJ, is Honour Judge Murdoch, and those are references to his judgment, I'm assuming. The next AJ, appeal judge, those are all references to where you find the individual events referred to in Mr. Justice Ritchie's analysis. The Scott schedule is the document that is at the beginning of the supplementary bundle that starts at page 3, which I think was, yes, it was served in accordance with an order, I'm assuming an order of the County Court judge on the 30th of April 2020. There's a lot of detail in there. And then the final group of references, or column of references, relate to the supplementary bundle. And could I just take one point at the moment from this grid, which is at the bottom of page 1, and that is that in the context of everything that we've looked at and the frequency of the contacts between the police and Mrs. Woodcock and vice versa, is what happened on the 6th of February. Now, I know that's a little bit before the incident, but it's pretty significant. It's a text to Mrs. Woodcock to state, informing him, so conveying information that he's been arrested. And somebody called Police Constable Goodwin asks Esna by text to provide her new number so they can contact her. And then if you look at the references, we take the supplementary bundle at 169.
Sorry, the supplementary bundle?
Yeah, a supplementary bundle of documents in the Woodcock case.
It's only got 101 pages.
It's been broken down into 3, I think.
Well,
Oh, I see. It's the latest.
the whole thing is 261.
Yes, I see.
Yeah.
Thank you.
I'm grateful.
So sorry, 161 you want?
169.
169.
169.
Yeah.
Message to IP, fast SMS at 6:20 in the morning. Good morning. Just wanted to let you know that Reza was arrested by myself and my colleague at 4 o'clock this morning. He's currently in custody and will be interviewed later on this morning regarding the offences he's been arrested for. He'll be updated in due course. Kind regards, Goodwin. Further to my last message, your crime number for the criminal damage to your car is, etc. Please use this as a reference for insurance purposes and for changing your phone number, and for changing your phone number if necessary. When you manage to change your number, please call us on 101 and let us know the new number so we can contact you. There's absolutely no question that they had the number. And then the other references are, sorry, there's a bit of a voyage of discovery from here, 44 and 45. That looks like, yeah, that's the same. 44 is the same. It's just a duplicate. And then 45. Yeah, top of the page. Telephoned on new number on the log and updated the victim regarding bail date and conditions, 6th of February, that's at the very top. And then page 14 of the supplementary is the Scott schedule, and you can see there it's agreed. So I think this was to try and work out what was agreed and what was not agreed in terms of the facts. And under where it says agreed, that's the defendant's comment. Goodwin sends message to claimant by fast SMS that she has been arrested. Agreed. And then, I mean, I won't turn it up, but that presumably Mr. Justice Ritchie takes that on board well, maybe I should just look at it quickly. At paragraph 74 of the judgment. Yeah, at 6:20, PC Goodwin sent a message to the claimant by fast SMS informing her that RG had been arrested. Well, there's nothing there about the phone number. Yeah, no, nothing. So it's like, but just acknowledged there by the learned judge. Now, so just to complete the factual information for you, our skeleton covers this factual area at the core bundle 239 to 40, paragraphs 51 to 53. I mean, I won't go through it, but I dare say similar points have been made there, and that's our written argument there on the factual distinction, so you know where it is in the skeleton. And then 245, page 245, paragraph 62. I'll just read this. You have that. In Michael, as per paragraph 37 and 53, I won't go back, there was no prospect of an immediate exercise of control over the risk posed by the third party who was at large. It was a case of having to competently and timeously handle the 999 call and attend as quickly as possible. Contrast the facts here, as already set out, 37 and 51 of the skeleton, where A, the police had sufficient control over the risk posed by RG, and B, had already made a decision to arrest him, and there was an ongoing manhunt. Special knowledge, i.e. information which they believed and had no reason to doubt, of his exact location, that RG would attack the respondent at exactly 7:45, that the respondent was aware of, so the police were aware of his presence outside her home and was at increased risk of injury as a result of being the subject of a surprise attack. And they had the obligation and ability to control RG to prevent the danger he posed by the delivery of the warning. So there's a subtle twist or difference between this and you look at the two relationships between the defendant, so the police, and the perpetrator, and the police and the claimant. And in each case, the relationships are slightly different. But here, you are controlling the risk by reference to something that they could do in relation to their close and special relationship with the victim, simply by saying, as they've done so many times, he's outside. There are points on causation, which you'd answer the phone. You will make what you will make of the suggestion that she was so bold and was going to live her life as she pleased that even though he's outside and he's been trying to break the door down and she's hysterical a few hours earlier, that yeah, she'll go out and she'll confront him. In a very non-legal way, I got one word: tosh. Complete tosh. The background of this makes it completely obvious in terms of an inference on causation, for instance, that should have been drawn. I mean, Mr. Davies can, I think, make some brief submissions on causation given time. But I mean, maybe whether or not I'm pushing on an open door here, I don't know. But given the background and the points I've made on foreseeability, with everything that we've seen in all of its awful colour, that had she picked up the phone and had she been told that he was outside, the suggestion, which seemingly was being made by the police at the trial, and also then in front of Mr. Justice Ritchie, that there's no evidence on causation. You don't need evidence on causation in something like this. It's so obvious, unless you completely do a brain wipe and say that she was pretending, that she wasn't frightened, she wasn't at all affected by all of that. She would have stayed in, she would have locked the door. And I think the gap between the attack and the police attending was about, what, 2 minutes? I don't know. I mean, we'll that's one of the facts we'll agree. But it was really, really, really on a knife edge. So, and the legal obligation that we seek to impose upon the police under these circumstances is really very limited and very controllable. So,
is it implicit in that submission,
yeah,
referring as you did to the close and personal relationship,
yeah,
that the position of the police would be different if they hadn't given her helpful advice in the past and hadn't taken it upon themselves to ring her up from time to time and check on things?
It's that part of the narrative that creates the special relationship that is required in the Headley-Byrne construct.
Right.
And exactly what is necessary to get through that gate it's plainly very, very fact specific. So, and that's one of the things that, if I ever get there, you will see when we look at a few of the cases, that assumption of responsibility as a concept is extremely fact sensitive. And that's a point, I think, that is made straight in the Supreme Court judgments.
Yes.
So to have something, so to hang on to the facts of Michael and somehow convert that to a hard legal principle cannot, in my respectful submission, be right. It's just not, it doesn't accord with the subsequent jurisprudence. It doesn't accord with the previous jurisprudence. There are many ways, the words that Mr. Justice Ritchie uses is there are many triggers. There are different triggers for an assumption of responsibility. In fact, he says it towards the last sentence of paragraph 100. This is Lord Toulson, sorry. Lord Toulson says at paragraph 100, there are many instances where the assumption has been imposed by the court. So it's nothing to do with the voluntary actions of the combatants in the case. And that is, we don't have it in the bundle. I think we got references in one of the footnotes to my overly long detailed skeleton. Phelps, Henderson and Merritt, Williams and Natural Life. All of those cases are examples of an assumption of responsibility which is imposed on the creation of the legal duty is because the judges have decided that it's appropriate to impose a duty of care. And that can be you take into account everything, take into account the conduct, take into account the words. Sometimes there will be specific assurances. Sometimes, but depending upon the circumstances, that specific assurance might not necessarily be required. Now, so getting back to the note, special relationship, implicit and express assurance. In Michael, no safety plans, no cocoon. In our case, we've gone over it, the relationship could be traced back to 2013. Joanna Michael in no different position really to all members of the public at risk of imminent harm. I'm not trying to go there. I am not trying to produce a massive floodgate-style class of litigation where the police spend all their time in court, spending time and money and being, and that's defensiveness policy, even though defensiveness, of course, was, put to bed, first of all, in capital and counties by Lord Justice Stuart-Smith. So, and then again in Michael, of course, defensiveness there's much force in Mr. Bone and Miss Monaghan's submissions on defensiveness. So that sort of feeling in the background, which is often maybe in a judicial mind, well, even though we're looking at omissions, and read Lord Mance, what Lord Mance says about this. There is always a policy element sitting behind the way that the common law has decided to do things. And here, Joanna was not in the same position as Esna because of that close, upfront and personal interaction between the state and the individual. Now, also, point of differentiation, if you're with me on how I've put in the skeleton the making matters worse, increasing of danger to Forest 2 case, of course, that's another point of distinction with Michael. And then there are arguments in relation to the control point. 103.
I'm sorry, are you submitting that by not phoning, they made matters worse?
By not passing on the warning. Yeah, I mean, I'll come to that separately.
You're saying it's a conventional matters worse?
Yep. Yes.
Fine. Don't take that your way.
The
way you referred to it, I wasn't quite.
Yeah, I think so. I think I referred to this a while back now. Paragraph 46 of Tyndall, where your lordship's approach, because really effectively of OLL, that you need that higher test. So you apply the East Suffolk counterfactual, I mean, it's all. I can't articulate it better than the way that the judges do in Tyndall. I think at paragraph 46, that matters have been made worse, but by the fact that let me just get that up again. I mean, I'll get when I get to that part of my submissions, but it's a combination of paragraph 45 and 49, I think, of Tyndall. In advancing this argument, the claimant's counsel relied on the submission of the police that the police made matters worse by creating an additional danger. And the second exception of Tafaris, we see no substantive difference. I've already read this. The exception relied on that A has done something which prevents another from protecting B from a source of danger. And of course here we say factually, and you looked at this with Mr. Warnock, if the call handler had not expressed himself in the way that he did to the neighbour, and if nothing had been done, and the neighbour had seen that, the neighbour, we say, there's enough there to infer that the neighbour would have shouted a warning, would have done something. It's a very short. You can infer.
The neighbour would have done something.
Yeah, you can do that because it's a very, very short time scale. She knows that there's been a manhunt. The neighbour knows that. The neighbour is, of course, reluctant to get involved, but certainly doesn't rule it out. And well, let's actually look at that as I've unintentionally got there. Page 90 of the supplementary bundle.
Well, I'm sorry, I only wanted to know whether you were saying this is a making matters worse case. And the answer is yes, if the call handler had not expressed himself in the way he did to the neighbour and nothing had been done, it could be inferred that the neighbour would have done something.
Yeah, and it's page 90. I've been trying to contact her, but she's changed her mobile, of course, on advice of the police. So there's no way of me, i.e. contacting her, unless I go over. I don't really want to get involved. So it's, it's ambiguous. And then on the next page, 91, okay, I'm going to get the officers to go straight round. We need, obviously, to stop anything taking place. And I'll have a look and see what we know about them. So there, the neighbour assumes, I know there's inference here, of course I accept that. I accept the neighbour wasn't called. But the neighbour is aware that the police, of the domestic violence and the problem that has been happening in her household. And she knows there's a man there who's about to attack her and the children when she comes out in 15 minutes. So she's not going to go in and put the kettle on and make a cup of tea. She is going to be intensely involved in the drama that is unfolding next door. Now, if the police had said, I'm really sorry, we have no officers, or if that call had not happened, applying the East Suffolk County counterfactual, what's the answer? The answer is that somebody would have done something. All she had to do, when Esna walked out of the door, if you look at, I think it's paragraph 47 of her witness statement from memory, which...
Whose witness statement?
Of Mrs. Woodcock's witness statement. Somebody might have to help me here, but I think it's in the judgment from memory.
The witness statement is one too.
Yeah, but it's quite. This is a witness statement. Sorry, I'll hunt around for this. It's quite important to take on board exactly what happened with the attack itself. And I think. hoping for help from behind, because I'm going to have to do it from memory otherwise. But what happened was, and I will find the precise paragraph, is she got out, she left the house with her children. He was not at that stage directly outside the front door. So he didn't open the door to then be, oh, I'm very grateful, SB 131. Thank you very much indeed. That's Paul, once we were. So page 131, I'm told, of the supplementary bundle. Yeah, paragraph 47, thank you. In the morning, I got the children ready for school as normal, but because of what had happened the day before, I was going to drive them to school myself. The police car had not returned, so that's the point about Sergeant Goosey deciding that he was going to stay, and he stayed till 3 o'clock as a sort of just a watcher to make sure nothing was happening. Police car had not returned, left at 3, so it's now 7:30. Everything looked normal when I looked out of my bedroom window as I was getting ready and just before I left the house. My ex-husband had stayed at the house and I asked him to leave the house at the same time as me, as I was anxious. I opened the front door at approximately 7:30. So there might be something a bit wrong with the timings there because the neighbour's call was 7:32. So it's probably more like 7:45, I suspect. Took the children to the car. So she walks from the door to the car, took the children to the car and they got in. So all that must have taken a bit of time. My husband went to his car. As I was walking around to the driver's side of the car, Michael shouted, "Mr. Guzzerillert was coming." Mr. Guzzerillert pinned me against the wall by my throat, lifting me off the ground. He had a knife concealed up his sleeve, stabbed me 3 times in my chest. Jade had got out of the car and tried to pull him off me. He swung around at Jade, but then turned back to me and stabbed me again. Michael came over and I managed to free myself. I ran across the road but fell. Mr. Guzzerillert got past Michael, sat on me and started stabbing me in my legs. Michael managed to knock the knife out of his hand and he ran off. I got to my feet and ran to a neighbour's house who allowed me inside. The next thing I knew was the paramedic was there. Now, the point about that, which is, I think, really important, is on my counterfactual, a bit like the wall and the dam that we were talking about yesterday. Had they done nothing, had the police not been an actor in the drama, the neighbour looks out of the window, the neighbour knows that he's there, she doesn't want to get involved, so she stays at the window. Esna Woodcock opens the door, comes out. She screams, "For God's sake, go back inside." He's there.
Mr. Bowen,
I'm sorry.
It's one thing to invite an inference.
Yeah. Okay.
It's another thing to write a dramatic script.
All right.
Can we please?
Forgive me.
No. I want to say this.
Yeah. Okay.
Can we please remember where we are?
Yeah. Okay. I accept that. I accept the criticism. I apologise. But obviously the stakes in this case are very high, and the counterfactual, the dry legal counterfactual, I say works. I mean, it works effectively, and it works on an intellectual and a legal level. And because Mr. Warnock will say, well, it made no difference. It made absolutely no difference. So, with that point thoroughly taken on board, my lord, that is my lords, that is my point on that aspect. So, So, real proximity, real course of dealing, made all those points. Factually, obviously, I say with respect, distinguishable. All those points have been made. Reliance 108 of HXA no longer required in cases involving dependency and vulnerability. So that point alone, if 115 as paragraph 115 of Michael and with the facts imposed as he does at 135 and 138, on the basis that you need a clear representation and reliance, I've made, probably in far too much detail, my representations on the facts, and that's the representation or the assurance. Reliance, well, query, where are we now with looking at Lord Toulson's test without reliance? Reliance is all about, it's implied, and the detail is in the skeleton, and the references to the authorities are in the skeleton, that it's no longer necessary. So the whole approach of Lord Toulson at 115, if it means what Mr. Warnock says it means, now is up for grabs if reliance has gone. Now, alternatively, as I think I've probably made this point, I've gone through the facts, we'll sort it out, don't drop the charges, all of the detail. I won't go through all of that again. We satisfy the test. That is the, so either the test can be looked at again, and I made those submissions, or if I'm wrong, and there is a rigorous test, we satisfy it. Now, so if we now go back to Tyndall and the point on assumption of responsibility that their lordships make at 519 of the paper bundle, 521 electronic. You can see there.
Paragraph?
75.
Thank you.
Elusive, while somewhat elusive, and possibly having different requirements in different contexts. Pure economic loss and misrep for present purposes. So present purposes being a case against the police, totally different context, but again a failure to protect case in the broadest sense. An assumption of responsibility involves the idea that a person may, by words or conduct, expressly or impliedly, promise or undertake or give an assurance to take care to protect another person from harm, i.e. it is not compulsory anymore to require a formal verbal representation, certainly for present purposes, i.e. a case of failure to protect in relation to the police service. In some situations, but not all, for an exception CHXA 108, it's also a necessary element that the claimant has relied on this promise. But anyway, even if it was required, reliance is satisfied on the facts. But I say in a case like this, it's probably not a requirement. An example is provided by Kent and Griffiths, where the call handler for the London Ambulance Service gave assurances that an ambulance would attend with reasonable speed. By contrast, in Michael, it was found that the police call handler had made no such promise. The principle of assumption of responsibility can also be invoked to explain the duty of care that arises when a person voluntarily accepts a specific role or enters into a specific relationship with another person, which carries with it recognised responsibilities to protect the other person's welfare. A classic example is the relationship between a professional person, client, and patient. So, elusive, probably has different requirements in different contexts, and tellingly, economic loss cases and misrep cases are the example given. Focusing their mind on what they're dealing with, a police case for present purposes. And that is an allegation of failure there to protect Mr. Tyndall. This is an omissions case, an allegation of a failure to protect viral warning. Then they're all listed, we've seen them. Words or conduct, promise, express or implied, undertakings, reliance not necessary. I won't turn it up, I think you've already seen it, but it's core authorities. This is 108 HXA, is for your note, 492 on paper, 494 on screen. That is another undermining of Lord Toulson's test.
Sorry, I didn't hear that last bit.
Oh, sorry, forgive me. I mean, I think I've made the point already. That the 108, in fact, it's 106, I think, to 108, undermines Lord Toulson's test because they are taking away one half of the requirement that Lord Toulson says, or said he says, in every case that is on that is either on all fours or analogous with the type of case that Michael was. You see? It's the section on reliance starts at 491 of HXA, Lord Burrows and Lord Stevens. We agree with Lord Justice Baker that it's plainly incorrect to say that there can never be an assumption of responsibility by a local authority in respect of social work functions to protect a child from harm. The obvious example is where the local authority has obtained a care order and thereby taken on parental responsibility for a child. In that situation, therefore, the local authorities assume responsibility to use reasonable care to protect the child from harm, including harm from third parties, Barrett referenced. And then 107. We also agree with Lord Justice Baker that it's incorrect to say that there can only be an assumption of responsibility, whereas in Barrett, the local authorities obtained a care order. And then footnote on reliance, 108. In the last two paragraphs, we discuss situations in which there may be an assumption of responsibility and hence a duty of care by a local authority to protect a child from harm. That discussion suggests that it appears not to be a necessary feature of an assumption of responsibility in this area that there is reliance in any real sense by the claimant. Because plainly here, in terms of my neighbour scenario, she can't rely directly because she's not given the information. For instance, cases like YXA, and then the facts of that case are set out. So given that, in my submission, it would be surprising to insist on satisfying those requirements in something which is not a full-blown protection case, where a legal duty to take active protective steps is imposed to avoid physical harm, merely a failure to convey information, failure to warn. So as long as you're not formally bound by Michael, there is a big green light in my respectful submission, and not the first post-Michael either. In other cases where failure to protect allegations are in play against the test, but the rigour of the Lord Toulson section paragraph 115 test has not been applied. Finally, noteworthy that their lordships, and I think I'm going back here to Tyndall, in the Supreme Court, they then mention Michael, and they cannot have been but aware that they were setting out a markedly different and more flexible test than Lord Toulson was. They merely say the call handler made no such promise. They say nothing to support the continuing requirement for a clear representation and reliance in every police failure to protect case. The reverse, I say, is the case. And it undermines any suggestion that there is a universal application for this test. So you're not bound. You don't have to apply a 115 test. We argue any way we can meet it. Now, could I now just make some quick points on DSD? slightly moving away, I suppose, from assumption of responsibility here, but I just want to do it chronologically through authorities of, so going backwards from Tyndall, then DSD. So, and DSD you find in the bundle I've just put away. Starts at 213 of the core, 215 electronically. So here, the police, supported by the government, were trying to say that there was, to undermine, to attack the decision of the Court of Appeal that there is a duty to competently investigate an Article 3 violation. The long-standing rule that the police couldn't be sued to fail to investigate crime, they said, meant that the policy of the common law had to be reflected in the approach to the HRA, where the only obligation was to have a structure of laws to protect Article 3 rights. And then if you look at what Lord Panic and Mr. Johnson, as he then was, say at 220. At letter B, the consequences, therefore, are the courts erred in law in imposing such a duty on the police. The consequence of the decision of the courts below that an investigative duty arises under Article 3 is to introduce an unnecessary and undesirable conflict between the common law principle that it's not fair, just and reasonable. So they are here post Michael and Robinson using language of, it would be said by Mr. Warnock yesteryear, to impose a right of action in damages for investigative failure, and the establishment of such a right through an expansive reading of Article 3 erodes the fundamental principles established by the common law. And then Sir James Eadie at 221.
Two how many?
221.
Thank you.
Second paragraph, the House of Lords and Supreme Court have repeatedly concluded that no duty of care is owed or should be imposed at common law on the police in respect of the investigation of crime. No proximity between investigating police and potential future victims of an unknown criminal. So they're talking here about pure Hill, not catching a criminal. Reasons of public policy preclude the imposition of a duty of care. Reference made to Hill, Brooks, Van Colley and Smith, and Michael. No reference at all to Michael. No reference to Robinson, and I think no reference to. Reference to Michael, but no reference to Robinson. This judgment.
I'm sorry, it was argued before Robinson. One sees it was argued in March 2017.
Hang on. Okay, well, the point is still good, because it was the decision, the judgment was delivered 10 days after Robinson. And there is no, let me just work through the references. And then if we go straight to the judgment at 226 of Lord Kerr. Paragraph 8. The Court of Appeal in the present case had emphasised the importance of consistency between the common law and the HRA. It would be anomalous, the appellant contends, for there to be different bases of duty owed by the police at common law and under the HRA. Many of the public policy considerations which militated against the recognition of such a duty at common law apply with equal force to the duty to investigate that arises under Article 3.
This is rehearsing the arguments.
And then at 66, does paragraph 66 to 67 at 240 on the screen, I think. in 66, the relevance of the circumstances that there is no common law duty of care. In Van Colley and Smith, two associated cases heard together, the complainant was that the police had failed to follow up reports of threats to kill, and then the facts are set out. Then the appellant relied solely on the common law, alleging negligence by the police. The House of Lords, para 136, rejected the argument that the common law should now be developed to reflect the Strasbourg jurisprudence about a positive obligation. And then we tried the same in Michael, and again with the same result. And then 67, as Lord Justice Laws in the Court of Appeal in this case pointed out, the essence of the argument on behalf of the appellants in those cases was that the common law rule, the police owe no general duty of care to identify or apprehend an unknown criminal, nor a duty of care to individual members of the public who might suffer injury through those criminal activities, Hill, should be moderated to accord with ECHR. As he observed, the converse is contended for in this appeal. The appellant and the Secretary of State argue that the exemption from liability of the police at common law should be extended to claims advanced under the HRA, so that the two systems should be in harmony. There are two reasons for rejecting this argument. And then he sets them out at 69 through to 71. And if you just look at those, at 69, secondly, and more importantly, no assumption should be made that the policy reasons which underlay the conclusion that an exemption of the police from liability at common law apply mutatis mutandis to liability for breach of the convention. In Michael's case, much of the debate as to whether policy owed a duty, much of the debate as to whether the police owed a duty to an individual member of the public centred on the question of whether there was a sufficient proximity of relationship between the claimant and the police force against whom actions were taken. No such consideration arises in the present context. The other principal argument advanced on behalf of the police in Michael's case is that it wouldn't be fair, just and reasonable to impose liability on them for failings in individual cases. This is a concept with which the common law, with its innate flexibility, which is exactly what I'm arguing for here, can cope, but it's not one which can be accommodated under the convention. The police either have a protective duty under Article 3 or they don't. The presence of the duty cannot depend on one's conception of whether it's fair, just and reasonable for it to exist. And then Lord Hughes has said in paragraph 132 of his judgment that law enforcement and the investigation of crime involves a complex series of judgments and discretionary decisions, that they concern the choice of lines of inquiry, the weighing of evidence, and the allocation of finite resources. All of that is unexceptional. But the claim that to revisit such matters step by way of litigation would inhibit the robust operation of police work, divert resources from current inquiries, and act as a deterrent, not a spur to law enforcement, is unsupported by evidence. And then the sideline part, carrying out police investigations efficiently should not give rise to a diversion of resources. On the contrary, it should lead to more effective investigation of crime, the enhancement of the standards and savings of resources. There is no reason to suppose that the existence of a right under Article 3 to call to account egregious errors on the part of the police in the investigation of serious crime would do other than act as an incentive to avoid those errors and to deter, indeed eliminate, the making of such grievous mistakes. Now that has will have plain resonance in the next case, CJPJ, and my learned friend, Mr. Chapman, will be addressing you on Article 3. And then if we just look at the dissenters at 259 on the screen.
Sorry, what is the purpose? If you're not addressing us on Article 3...
Why am I doing this?
Why are you doing this?
Well, the reason I'm doing this is because in this case, there was a complete unanimity in policy terms, with no mention of Robinson, no mention...
In Mrs. Woodcock's case?
Sorry, no, in D.
In D?
In D. I mean, this goes to...
There was unanimity about what?
There was unanimity about the strength of Smith and Brooks. There is nothing, it's a point I made at the very beginning, that there is nothing. If you look at this, it's pretty surprising. It's been said by the commentators that here, even though there were common judges on the panel, I think 3 common judges, there were both. I'm sorry, the cast list escapes me. But I think there were 4 of the judges in Michael, or there were common judges in both Michael and Robinson and on this panel. But there was nothing to suggest in this case that the undermining, as it's said by Mr. Warnock, I think, is it paragraph 34 of Robinson, where he took you to sections where the old cases have got to be looked at with caution. Smith and Brooks particularly has to be looked at with caution because it can't fit in with the omissions principle. So therefore, the part that the exceptionality category that's relied on in the alternative by me and more heavily by Mr. Justice Ritchie, or at least in parallel with assumption of responsibility, is untouched. So there is nothing to take away from those parts of Brooks and Smith which I haven't actually taken you to yet, but all essentially say there's got to be an exceptional category, cases on the margin. Lord Steyn says, I think in paragraph 30 or 34, there may well be a category of outrageous cases, but I don't want to guess what they might be. We'll have to deal with them as and when they come along. So that is the purpose of this, and I say with respect, it's significant. But so we have much the same from Lord Hughes, from 130 down to 131. Now I accept, of course, here that what they're doing is they are emphasising the continuing existence of the policy-based core rule that the general rule is that you can't sue for a negligent investigation. But in that context, the gravamen of Smith and Brooks is both that, but there is an area where it won't apply, special circumstances such as. And so if I just give you the references there, 130 to 131, core 259, Lord Neuberger, paragraph 97, core 243. So Brooks and Smith upheld in their entirety, no discussion how they fit into omissions. Any suggestion that Mr. Warnock might make that there is any form of implicit repeal is respectfully wrong. Can't say that the exceptional category is no more. So then I've looked at HXA. I've dealt with HXA on reliance. Just a few more references on reliance. I won't turn it up, but the De Silva fishing case at core 238, which is referred to at paragraph 49 of our skeleton. I'd like you to have a good look at that. That's quoted both in Selwood and I think in either Brooks or Smith. White and Jones, there are some very important aspects on reliance and assumption of responsibility. And could I just give you the references? It's reported at 1995, 2 appeal cases 207.
Sorry, is this something that's not in the bundle?
No, this is in the bundle. This is in the bundle.
95, 2 AC, what?
207. And the sections are 271H to 272A, 275 letter C to F. This is all in the supplementary bundle of authorities. pages 171 and 174 per Lord Brown Wilkinson.
Just hold on a second. 275C to F, and now you're giving us the bundle reference, which is
171 and 174. And then Lord Musthill, 288 B to C, Supplementary Authorities 187.
I'm really sorry, I'm a bit behind you. You're now, you were talking about Lord Brown Wilkinson, you're now talking about Lord Musthill.
Yeah, no, these are just sections that you may find helpful on reliance.
Page?
Page 187, 288 B to C of the report. And also at my skeleton, core 239 of the Woodcock bundle, paragraph 50, and the reference to what Clark and Linsell say on the subject. And also for completeness, footnote 48 of the skeleton, but I suspect you have enough already. And then finally, before lunch, pool, core authorities 3, 4, 5. If you just look at 343, paragraph 88. What I'm driving at here, which is Lord Reed, core 338 to 339. Oh, sorry, that's a paper reference. And then 345.
Sorry, you're on paragraph 88, which I've got.
Yes, well, if we just stick with that, what comes out of this is assumption of responsibility is not confined to the provision of information and advice. It's a concept that is highly fact sensitive. And if you look at the paragraph, as explained, however, the concept of an assumption of responsibility is not confined to advice and information. It can apply, whereas Lord Gough put it in spring, the claimant entrusts the defendant with the conduct of his affairs in general or in particular. Such situations can arise where the defendant undertakes the performance of some task or the provision of some service for the claimant with an undertaking that reasonable care will be taken. Such an undertaking may be expressed, but it's more commonly implied, usually by reason of the foreseeability of reliance by the claimant on the exercise of such care. In the present case, however, there is nothing in the particulars of claim to suggest that a situation of that kind came into being. And the same fact-sensitive point is made at paragraph 54 of our skeleton relating to the Mitchell case, core documents 241. And I won't go through it now, but I just ask you to sideline the whole of that paragraph upon which I rely.
that a convenient point?
Yeah, I mean, just give me one moment. Yeah, that's, thank you, my lord.
Where do we stand on overall timetable, please?
Well,
I'd like to know precisely.
yeah. Oh, well, I would have hoped to have finished in an hour or so after lunch. I mean, Mr. Warnock did the whole of the day yesterday. It took an hour longer.
I'm just asking for where we're up to on timetable.
Yeah, I think we're on course.
No, I want to know. You'll be an hour, and then what's to come after that in the Woodcock case?
Yeah, and then of course Mr. Warnock will reply, and then
At the moment I envisage that'll be very short.
Thank you.
Yeah, and then I'm just going to open the CJ on the facts and take you to some of the essential findings of fact of the disciplinary panel and the judge, and then I'm going to hand over to Mr. Chapman, and in the time that's available for him to start Article 3.
I think perhaps Mr. Davey may want to remind you of something.
Sorry?
I think Mr. Davey wants to remind you of something.
Sorry, thank you. And there's a short, Mr. Davey will address you shortly on causation in relation to Woodcock when I'm done. But I don't anticipate that will be very long. Then we've got all of tomorrow. Overnight I will try and keep my submissions on the negligence aspect, because I've done so much today on CJPJ. And Mr. Chapman's got a fair bit to say on Article 3. So I think we should be okay.
Well, I'm afraid I think we should be okay is not good enough. This case was listed for 3 days at a time before it was known that the Supreme Court was about to pronounce, and has last week pronounced, on matters which are very central to the issues in these cases. We will not be able to sit beyond about 3:30 tomorrow afternoon.
Okay.
We will need to consider at the end of this afternoon where we're up to, and if necessary, the court will need to impose a timetable for specific parts of the submissions.
Right.
So I'll leave that to counsel to debate and be in a position to assist us, please, at the end of the day.
We will do that.
But for the moment, we'll rise till 2:05.
Court rise, please.